Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And this video is kind of a recap of a live stream I just did. I know live streams are not everyone's favorite. Sometimes you just want the information, and that's what this is. No silly chat or any distractions. This is just the information. This is the update on Hambly versus Loader. This is the quartering being allegedly attacked by Matt Loader, otherwise known as Prettiest Matt. And this was at Gen Con in 2017. Of course, this lawsuit is going on. So that said, I have gone through the complaint, the amended complaint, and the answer document that has now been filed by Matt Loader's attorney. I'm going to compare and contrast what I find to be the important sections of this document and talk of these two documents and talk about the corresponding paragraphs and give you my sort of take on the issue and what I think are the legal goods and bads in these two documents. Okay, so that said, let's jump into this. This was a long delay in getting this answer filed, and I believe that delay, if I understand Jeremy Hambly's words on this, is that Matt Fantastic actually hired an attorney in Wisconsin. This happened at Gen Con, which is in Indiana. So Hambly hired Bill Richmond, got his name, Steven Crowder's half-Asian lawyer, Bill Richmond. He hired him. He is not in Indiana. I believe he's in Dallas. I can take a peek real quick. Yes, Dallas, Texas. But he hired him. And then Matt Fantastic hired Stephanie Loshing, who is an attorney out of Janesville, Wisconsin. And not sure why he would hire a Wisconsin attorney to do a case in Indiana, but he did. And there was discussion, from what I understand, about moving the case out of Indiana courts and into Wisconsin courts. That apparently has broken down, and the case will be heard in Indiana, which is pretty appropriate because that is where the alleged events took place. That would give Indiana the most likely case for jurisdiction over all of the parties involved, because if someone punches someone else in a state, that state definitely has jurisdiction over that person. So the allegation should be enough to raise personal jurisdiction, but we'll talk about the jurisdiction at issue as we go. Now, enough babbling for me. Let's go on to this. So the first part is jurisdiction and venue. The most important part of this is something called subject matter jurisdiction. In this case, it's based on federal diversity jurisdiction. That means that the parties at issue, in this case, Hambly and Loader, must be completely different as far as their state citizenship goes. Hambly is a resident of Wisconsin, a citizen of Wisconsin, and defendant is a citizen of Connecticut. Okay, that is diversity of citizenship. So that's the first part of the issue to bring this into federal court. The second part of the issue would be the amount in controversy must exceed $75,000 exclusive of interest and costs. So you can't count attorney's fees and you can't count interest on the damage if this has been, like maybe 2 years and you're within the statute of limitations. You could build up quite a bit of interest depending on the amount of money. Has to exceed $75,000. Now, this is a good faith estimation of damages, and a lot of deference is given to reasonable damages asserted by the plaintiff. This is not a high bar to pass, especially when you consider the lost revenue that Jeremy is alleging. Alleging lost revenue. He's alleging physical trauma to him that he was treated for at some sort of medical care facility. that gets expensive very quick. He's alleging emotional damages. There's additional pain and suffering that goes along with that. There are different concerns like potentially security concerns or whatever going forward. Racking up $75,000 in damages, especially when he's been banned from Gen Con, from what I understand to be for life. That means that he can never gain revenue from that source again. He's going to allege all of that. He doesn't have to prove all of that. But let's see what their response to this is. So I've highlighted the amount in controversy exceeds $75,000 exclusive of interest and costs. In their answer, they say they don't have enough information to admit or deny, but they hold the plaintiff to the strictest burden of proof permitted by law that the amount in controversy exceeds $75,000 exclusive of interest and costs. This is going to be, again, some sort of disclosure of a list of damages reasonably asserted, and then that'll be pretty much the strict burden of proof. It's not very strict on an initial pleading. Pleadings are generally done, especially when you have an opposition, with the facts at issue or the allegations at issue read in favor of the party that is not making the claim. So they're claiming he doesn't have $75,000 in damages, then it would be read in favor of Hambly. So Hambly just has to lay out the damages that he believes he's suffered. If that totals $75,000 and 1 penny satisfies the requirement, it's a very low procedural bar. However, I do think it might be their most valid avenue of attack at this point, because if they can defeat that and defeat subject matter jurisdiction, complicates things and means that Hambly would have to refile, and it would add time and expense to everything. It'd be a mess. Okay. Paragraph 4. The court has personal jurisdiction over defendant because defendant's actions giving rise to this suit took place in Indiana. They respond that it calls for a legal conclusion, therefore no response is required. A legal conclusion in a pleading document does not merit a response, and it is thrown out by the court. It is ignored. It doesn't matter. However, this is not a legal conclusion. This is a statement that the facts alleged in the pleading occurred in a place. That's not something that a jury would decide. Whether or not it occurred there is a question of fact that would be pretty easy to resolve. It doesn't call for a legal conclusion at all. If the facts as alleged, not even the facts as occurred, the facts as alleged occurred in that state, then they have jurisdiction. That's how it goes. Defendant denies all allegations and holds plaintiff to the strictest burden of proof permitted by law. Again, low bar there. This is pleading standards are this: time, place, names. When did they happen? Where did they happen? Who did they involve? And statements in pleadings are presumed to be true because they're made under oath. Okay? So just saying this is a legal conclusion is actually not right. It's actually an incorrect statement. Okay, so the next one. Venue is proper because all of the events giving rise to this suit took place in the Southern District of Indiana. Calls for a legal conclusion. No, it's simply stating, again, that the facts alleged in this document are alleged to have taken place in Indiana, and therefore Indiana has jurisdiction. And they do. They absolutely do. So this court, of course, would have the Indiana federal court, because this is a federal case. Okay, moving on. So on jurisdiction and venue, there's almost no question that the court has personal jurisdiction. There's a teeny tiny question that they might not have subject matter jurisdiction, but I can't really express how low the bar is for this. It's pretty much if you say it, and a court could even come close to reasonably concluding that taking everything at the plaintiff's words, they get there. There you go. You got it. It's a really low standard. And saying that that might be their best form of attack is intentional. I really do think Hambly has a good case here, unless he can't produce any witnesses or something like that. Then it makes it harder. Not necessarily that hard. It would depend then if Loader's got people saying, no, he wasn't even there. You know, that would be different. But we can actually see. We'll get there. Paragraph 12, defendant is the individual depicted in the below photo. So here we go. Here's Matt Loader in a Punch Nazis Savage World shirt with a fist. Fist. You don't want to know what he's going to do with that fist. Trust me. Defendant admits to the allegations contained therein. So the defendant is admitting that that's him in the picture, yet denies any characterization of the photo contained in paragraph 12. There is no characterization of the photo contained in paragraph 12. This is a weird forecasting of, you know, what their problem is. I mean, the problem, of course, is that he's making a fist and he says punch Nazis, although that doesn't mean that he did anything. It doesn't mean that he did anything. It's obviously why the plaintiff would choose this photo. However, the court already knows that it doesn't mean he did anything in this instance. Anyone can wear this shirt. Anyone can make a fist gesture and not be guilty of assault. Amazing. But denying the characterization is a little silly. Paragraph 13. On information and belief, on May 14th, defendant in an interview with Rob Kalajian stated, but then there's also time to just start punching Nazis because F those guys. They do have a citation to the article there. Admits the allegations contained therein. So he did say that, yet denies any characterization of the language contained in paragraph 13 as it does not represent the entire contents of the interview. Well, good. Let the judge go read the contents of the interview where you gleefully talk about punching Nazis and talk about being a Krav Maga instructor who's trained to deal with violence in a different way than normal people. You silly goose. It doesn't help you. It doesn't help you. But that's their answer there. If you want to check out the thing, it's on hansperspective.com/nor'easter-matt-fantastic. It's exactly what you'd expect it to be. Boring interview from a boring person to a boring person. Paragraph 14, on information and belief on June 5th, defendant drafted and published the tweet captured in the screenshot below. Matt Fantastic, real talk. If you have a problem with Femme Freak being invited to Gen Con, effing fight me. I'm easy to find. And Matt might need to work on his language. Paragraph 14, defendant admits the allegations contained therein, yet denies any characterization of the language contained in paragraph 14 and affirmatively alleges that the tweet speaks for itself. So there you go. He says that the tweet speaks for itself. I didn't actually highlight this, but I'll briefly talk about it. They say the phrase real talk indicates that the following language was serious and not satirical. Typically, real talk does mean real talk. That's the usage of the word real talk, especially in a text type environment where context is absent from what you're typing. You would type real talk if you want people to understand that you're being serious. Now, does it mean someone always is? No, probably not. It's the internet. But, I mean, that's why you say it, right? So here we go. Their response is that defendant specifically denies that the phrase real talk indicated that any language was serious and not satirical. And further, defendant is without sufficient information to admit or deny what Hambly has or has not publicly criticized in the past, but believes that he has publicly criticized the organization Feminist Frequency in the past. He denies all other allegations. So there you go. Real talk doesn't mean real talk. I don't know if he's ever denied it, but I'm pretty sure, or criticized him, but I'm pretty sure he has. Good defense there. 17. Oops. So this is the incident itself. These are the events, the facts alleged to have occurred at the Tin Roof Bar on, I think it was August 2nd. Yeah, early morning, August 2nd. Defendant approached Hambly from the sidewalk, reached over the railing to place his arm on or around Hambly and inquired if Hambly was in fact Jeremy Hambly. Hambly replied in the affirmative. Defendant began punching Hambly in the head and yelled, "I'm going to effing kill you." His favorite word, I think. Paragraph 17. This is the weirdest defense to this allegation that I can think of. Defendant is without sufficient information and belief to admit or deny the allegations contained therein and therefore denies the same. Just deny it. Just deny it. If your defense is that you didn't hit him, just deny it. But that's not their defense, I think, which is mind-blowing. It is a mind-blowing thing for them to say, my defense is not that I didn't hit him. Because that's the defense. I didn't hit him. Battery just means I touch you and you don't want to be touched. Battery, done, civil battery. All that's left is damages. That's it. If you hit someone and your defense is, I hit them, but I don't know about it, that's really, really weird. If your defense is anything other than, I didn't hit him, you've got a lot of ground to make up. So this is very strange. Next, 18. Defendant was pulled apart from Hambly by the other Tin Star patrons in his vicinity, at which point Hambly retreated from the patio to the inside in an effort to evade defendant. They again say they're without sufficient information and belief to admit or deny the allegations contained herein. If you weren't pulled apart and he didn't retreat inside, you just say deny. If you weren't there, you just say deny. If you didn't do anything, you just deny it. The only thing they can plausibly say they're without sufficient information and belief to admit is that he went in an effort to evade defendant. That's the only thing they don't know. Maybe he just happened to run into the bar and wasn't trying to get away from the defendant. Why they're not just denying these is beyond me. Now, this would be less of a mystery, except they do specifically deny things in just a couple paragraphs. This is very, very odd. 19. Defendant attempted to follow Hambly into the bar, but was prevented from doing so by a 10-star patron or some other individual. Furious that he was unable to continue his attack on Hambly, defendant punched the glass window of the 10-star building, causing it to break in view of Hambly. Again, defendant is without sufficient information and belief to admit or deny the allegations contained therein. Did you try to follow him in? No. Deny. Were you stopped by someone? No. Deny. Did you punch the glass? No. Deny. Were you trying to cause intimidation in this person? No. Deny. Just deny it. What are you doing? Just deny it. You weirdo. Deny it. Not, I don't know. I don't know if I was following him in. This is how this comes across. I don't know if I was following him in or not, so no. I don't know if someone stopped me or not, so no. I don't know if I punched the window or not, so no. And I don't know if I was trying to intimidate him, so no. Why wouldn't you just say no? None of it happened. Unless it did, right? Like, unless it did, you just don't know how to answer the question, I guess. I'm obviously mind blown here because it's a pleading document. You just say it didn't happen. You just deny it. On information and belief, on August 3rd, defendant drafted and published the following Facebook post. I'm keeping a lower profile, but I'm straight chilling and doing fine. Telling stories about me online is what it is. No charges. I haven't fled the con/state. I'm drinking beers, playing games, doing business with my friends, but I'm trying to keep my friends and their companies from accidentally getting in the line of fire if someone sees me in their booth or whatever. Lots of immature doxing garbage with wild false rumors and accusations flying around, but that's mostly just an annoyance. Thanks so much to everyone who's been reaching out to me or my friends in support. Expand City sold out in like 10 minutes. Hashtag punch Nazis. Okay. Defendant admits the allegations contained therein. So he admits he wrote it, yet denies any characterization of the language contained in paragraph 20 and affirmatively alleges that the Facebook post speaks for itself. Okay. Okay, paragraph 20. Yeah, that's that. All right. Moving on to paragraph 22. Language #punch Nazis read in context with the timing of the post serves as 1, an admission of defendant's attack on Hambly, and 2, an insinuation that defendant's victim, i.e. Hambly, was a Nazi. And defendant denies all of the allegations contained herein. So defendant has sufficient information there to deny, but not earlier. Again, really, really weird. But here's the thing. Of course he put #punch Nazis on there because he had just punched a Nazi. Of course he did that. It's the delusion of the justice warrior, the social justice warrior, the SJW, whatever it is, that they live in a fantasy world where consequences don't matter so long as the other person is socially unacceptable enough by their judgment. It's okay to walk up and punch Richard Spencer in the face because he's a Nazi. It's okay to walk up and punch Jeremy Hambly in the face if you determine him to be a Nazi. So of course he put it on there. Why he chooses to lie at this point is weird when he could have lied earlier. Like, if you're gonna lie in your pleading, you might as well. And everybody lies in their answer pleadings when they deny everything. And everybody denies everything because you just deny it. That's what people do. That's how answer pleadings are typically written. Now, of course, you want a discerning attorney to come in and actually thoughtfully go through the pleading and do admit and deny things as they are. And most of the time, that's what happens. But it does look weird when someone denies everything and then a bunch of witnesses come forward and say, no, they did it. Well, then you know that denial was a lie. And that's how it's going to be if Hambly wins this case. All of this stuff will be lies, and that's how it goes. But we'll see. We'll see. 25. Hambly, these are the injuries. Hambly suffered substantial injuries from defendant's attack, including but not limited to burst blood vessels, head lumps, cuts on his arm, multiple bruises, and emotional and physical trauma, preventing him from attending, e.g. substantial portions of Gen Con 2018, meetings scheduled with vendors and other obligations at Gen Con 2018, and creating Gen Con 2018 related content, which would have resulted in substantial revenue for Hambly. 25. Denies the allegations contained therein. Okay, he's got enough information to deny those. 26. Lost revenue includes but is not limited to revenue generated from the lost viewers for Gen Con 2018 content, which would have been created but for defendant's actions, and future revenue stream expected from the additional subscribers to the quartering and Unsleeved Media that would have directly resulted from the same. Denies the allegations contained therein. It's interesting that now he knows enough about the financial situation of Hambly to deny it without saying, I don't have enough information. But, you know, there you go. 29. Hambly also suffers emotional trauma from the prospect of attending Gen Con in the future or any convention similar to Gen Con, which is unavoidable due to Hambly's occupation as a social media personality. Emotional distress manifests in the form of anxiety, stress, panic attacks, and depression. He says, without sufficient information on this one. I just pointed out that they didn't just like switch to flat denials. They are choosing either to deny or to add not sufficient information followed by a denial. And it's a really weird thing that they've done it on the things that they've done it. Because they could have just consistently. I didn't do any of the others. Count 1 battery, count 2 assault, and then the request for the relief, money, and a restraining order. That's how it goes, right? Like that's all standard. What I did highlight is this, because this, when I read it, broke my brain. I still don't understand it. Okay, affirmative defenses. Defendant Matt Loader alleges as his affirmative defenses as follows. Plaintiff fails to state a claim upon which relief can be granted. This isn't an affirmative defense. And if this is the weird part of raising this as an affirmative defense. I actually checked Indiana case law on this. And if you are asserting an affirmative defense, the court will not dismiss for failure to state a claim because they'll dismiss based on the affirmative defense that you raise. Failure to state a claim is not an affirmative defense. It is a procedural motion. In this case, a Rule 12b6 motion for dismissal. Failure to state a claim upon which relief can be granted. This is federal court, federal rules of civil procedure. That's the rule. If you don't have a sufficient pleading, and definitely he has sufficient factual statements in this case to defeat failure to state a claim upon which relief can be granted. It's a weird affirmative defense because it's not one. I don't know why Stephanie Loshing put it in there. Maybe that's just how she drafts documents. Maybe it's stylistic, but it's very strange because it just doesn't belong there at all. An affirmative defense to battery is self-defense. Yeah, I was hitting him, but he hit me first. An affirmative defense says, I did the thing that they said I did, but there's a reason. Self-defense, defense of others, defense of property. You could maybe assert coercion or duress. Someone's got a gun to your significant other's head and says, you hit that person. Well, I mean, there's a reason that you're hitting the person. You hit him or I'll shoot her in the face, right? Like that's a reason why you would hit someone. Those are the types of affirmative defenses that we're looking for. Actually, there's a list of them laid out. None of these are on the list of affirmative defenses in the rule. In the rule 8.03 of the Federal Rules of Civil Procedure has all of the affirmative defenses listed. This isn't in them, or not all of them. It has the most common ones listed. None of these are there. Any and all damages incurred by plaintiff are the result of plaintiff's own negligence. That's not an affirmative defense. What they're looking for is like, I guess, contributory negligence. Okay. Correction. Contributory negligence may be under federal law still an affirmative defense. In Minnesota, it is not anymore. We use comparative fault. It's a different standard. So that may be still an affirmative defense in federal court, but it's not a complete bar, so it's not really an affirmative defense in that sense. It would be a mitigating defense. I don't know. All damages incurred by a plaintiff are the result of his own negligence. So I guess he negligently hit himself. Who knows? 3, plaintiff's damages are barred by lack of subject matter jurisdiction. Again, this is procedural. This would be a motion. This is not an affirmative defense. I've talked about the subject matter jurisdiction. They've raised it up ahead. They need to file a motion to dismiss based on failure to state a claim, I guess, which they'll lose heartily on. And then lack of subject matter jurisdiction would be dismissal probably without prejudice. They need to file a motion for that, not put it as an affirmative defense. Doesn't make any sense to be there. Fail is a result of the unclean hands doctrine. Problem for multiple reasons. Unclean hands applies in courts of equity, not in courts of law. Now, most states have combined law and equity, including the federal government, except for bankruptcy court is still a bankruptcy court of equity. Equitable relief, not legal relief, is provided. But federal courts and state courts still provide equitable relief. They just move away from legal principles and into equitable ones when it merits it. Sometimes employment actions are equitable, breaches of contract, those types of things can be equitable. Like I said, bankruptcy. Battery is not law of equity, and unclean hands is not applicable to battery at all. What unclean hands means is you want equitable relief for your case at equity, and they say, actually, this guy is not coming into this innocent and pure. He was deceptive or did this other thing, so he doesn't deserve that equitable relief. Equitable relief is making all parties whole where they should be under like a set of obligations. Unclean hands does not play into battery at all. Very strange to put that as an affirmative defense here. Finally, defendant reserves the right to amend these affirmative defenses as additional information is revealed. Oh, honey, you better amend them quickly because none of that makes any sense. None of that. Now, Stephanie Loshing, as far as I can tell, is an experienced attorney, probably more experienced than me. I don't specifically know, but she's well, he's worked for several law firms and clerked for a judge. Has been practicing longer than I have. I think there's no reason, like, this is very strange from this person, in my opinion. This is a strange set of defenses. This is a weird pleading. This is a weirdly drafted answer all around. Here's the deal, guys. If what Hambly says is true, he's going to win this case. That's how it boils down to it. Matt Fantastic sort of denies some of this stuff, but if Hambly can produce witnesses, especially credible witnesses, to come forward and either provide statements under oath or to provide direct testimony, yeah, I saw this guy do that thing, Loader's toast. There's no way he argues his way out of beating someone if someone else watched. All right? Like, there's no way that happens. Especially being a martial arts instructor, that might actually work very much against him. And that article that they cited where he brags about being a martial arts instructor and more equipped to deal with violence than the average person. And no offense to Jeremy, this isn't meant pejoratively, but he looks more like an average guy. He's a big guy for sure, but he doesn't strike me as like, and he doesn't present himself, to my knowledge, as a combat expert or anything like that. I mean, I've never seen him on an undercard. Maybe he's a martial arts guy. I don't know. He doesn't talk about it, to my knowledge. So if this case as written is correct, and it's very weird that Loader's defense is not, this never happened, I wasn't there. Because that's what the people are critical of in the comments, is like, oh, Jeremy's lying and making all this up. Otherwise, there'd be witnesses, there'd be all this stuff. Matt Fantastic should have just come out and said, wasn't there. Deny, 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 deny. If he wasn't there. Was he there? Did he do this? Kinda looks like he did. We'll find out, I guess, as things move forward. We'll see what happens. But as it looks right now, Hambly should meet the pleading standards just fine. And that $75,000 in controversy is not a very high bar to meet in a federal pleading. Because again, they're going to take all of his reasonable assertions as true, and they'll have to maybe do some minor accounting of his revenue or something like that. But it shouldn't be too hard to show. So anyways, guys, hope you found this video more informative and a little bit more to the point and narrowly focused than the live stream. Thank you for watching. Like and share this around if you know people who want to kind of catch up on the Hambly versus Loader lawsuit. If you don't subscribe to my channel, please do. I cover stuff like this all the time. And also we do live streams where we drink and make jokes and all sorts of fun stuff too. So thanks a bunch for watching. You guys have a good night.